And welcome in, everyone, to the Voice of College Football. So happy to be joined on this fine Monday by Tony Saracusa from Last Word on College Football. Please join him there. And we ask Tony the tough questions, so he is always up to the challenge.
We
Tony,
hope so.
Well, you cover college football, which means these days that you're spending most of your time in court.
It's true. Yeah, it's true. My parents always wanted me to go to law school instead of journalism school. And now it's proving that either one would have been okay. I guess it's a good thing I took all those constitutional law classes in college.
I took the one required media law class, and that was enough for me. And I checked out after that. So
I don't
I
blame
got
you.
through that one.
I don't blame you.
All right. So what you listened in on this afternoon was what you described to me as hearing number 2 in the ACC's motion to dismiss the case in Florida federal court.
Right.
So what transpired this afternoon?
So, and here's why it was hearing number 2. What we have in the Second Circuit Court in Florida is Florida State versus the ACC. Florida State trying to get out of the grant of rights, trying to get out of paying the exit fees to get out of the conference. This is different than the ACC versus Florida State, which was in Mecklenburg County, North Carolina. And of course, those will all be added to the ACC versus Clemson and Clemson versus the ACC, which will be held in different venues. This was or is the ACC trying to get the case dismissed, the case in Florida against it being dismissed. And all of these fights are turf wars. They're based on who has the jurisdiction to hear this. The ACC claims that, hey, we're based in Charlotte, North Carolina. North Carolina is the venue to hear this. Florida State says we have sovereign immunity because we're a state university in the state of Florida. The case needs to be heard down here. So this is the second hearing in front of Judge John Cooper. And in the first hearing, which was now 3, maybe 4 weeks ago, he ruled on several issues, but not the motion to dismiss. He said he needed to hear more on that. So that was where we were today. I'm gonna cut to the chase before I get into the details and tell you there's going to be a third hearing on the motion to dismiss and a date and time to be determined. It's more than a little troubling. Part of what happened today was the attorney representing the ACC, Amber Nunnally, presenting the ACC's case as to why the state of Florida and this jurisdiction was not the proper place for it. And then Florida State's attorney, Peter Rush, in this case, and let me point out, both sides have a team of attorneys. But Peter Rush went into his arguments, and Judge Cooper kept intervening and saying, you're arguing your case instead of arguing the motion to dismiss or arguing against it. And you're bringing in arguments on personal jurisdiction, which I have to tell you, I'm looking for them in your briefs. I'm looking for them in your summaries, and I'm not finding them. Now, let me digress for 30 seconds here. Every time Judge Cooper does that, it's a 10-minute delay in the process. Judge Cooper likes to, I don't really know if it's a brag, but so much as say, hey, I did all this research myself. I don't have a law clerk. And he'll show a binder this big and say, I did all this research myself. And then when he's looking for stuff, he can't find it in the binder. And you'll see the attorney, at the podium kind of tapping their fingers, trying to, be patient. For the love of goodness sake, Judge Cooper, hire a legal clerk, please. I beg of you. But he kept interrupting, repeatedly saying, you're arguing things that are not in your brief. And when they went to take a lunch break, he said, I'm going to give you, Attorney Rush, I'm going to give you the lunch break to think about what your oral arguments have been today and where you can better direct them. to match what is in writing, because what is in writing is what was submitted to opposing counsel. It's what was submitted to court. They came back and there really wasn't much argument left. Judge Cooper was ready to rule. He went back to chambers, reviewed one more case precedent, and then came out and said, here's what we're going to do. I am granting the ACC, I'm granting their motion to dismiss. However, I'm granting it with leave to amend. Now, for everyone who didn't take the law classes that you or I took, here's what it basically means. I'm giving the ACC this victory, but it's very limited in scope and very temporary. I am going to let Florida State amend their complaints. He's giving them a legal do-over. This is the equivalent of you're writing an essay for your college professor, and they're looking at it and they're saying, it's not really on the topic, but instead of giving you a grade that's going to be low because you didn't write it on the topic I gave you, I'm going to withhold your grade and let you rewrite it, let you do it all over again. Look, this is not uncommon in civil court to do a leave to amend. But the fact of the matter is the judge easily could have said, you know what? You didn't argue your case. You didn't argue it well. You didn't argue the points that were in your motions and your briefs. Therefore, I'm ruling in favor of the ACC, period, full stop. He didn't do that. He said, I'm going to give you a chance to do this. He said, and I'm looking at my notes for the quotes. He said, we cannot proceed with our eyes closed because of the magnitude of the case in front of us. So he understands that there is a case going on in Mecklenburg County, which somewhat mirrors this. He understands that Clemson has filed a lawsuit in Pickens County, South Carolina, to combat the ACC, and that the ACC is filing a countersuit against Clemson in Mecklenburg County, North Carolina. So he said that Florida State needs to argue with more specificity and that they need to be more on point. He said, because I cannot commit myself to what is in the complaint based on how you're arguing outside of the written part. So it's a do-over. And it's a do-over with a limited amount of time, but we don't know when the third hearing is going to be. And here's why. Because the Florida State, it will take a couple of days for the judge to put together his order in writing and then get it to both sides. From the time that they receive it, Florida State has 7 days to rewrite their brief, rewrite their arguments, include the issues of personal jurisdiction that they were verbally arguing, and then get it to the court and get it to the attorneys for the ACC. The ACC then has 20 days, 20 business days, actually, not including weekends, holidays, whatever else. They have 20 days to write their response because they're going to have to now re-argue some of the points that Florida State is making. At that point, and only when both sides are done, will there be the next hearing scheduled. And Judge Cooper made a point of noting that he already has hearings that are being put on his calendar for August and September. So in order to squeeze this in, he's going to have to look for what he would call a trial week, which there is a trial that he's hearing, but there may be a day off somewhere in that trial, and he'll put them in there. Bottom line is, we are not going to get to stage 3 of this process. And this is just step 1 of the process. This is a very preliminary step to anything. We won't get to the third hearing until early summer. I would venture to guess late June, early July before we see it.
So Tony, just to maybe give a different explanation to what you just stated about the judge's ruling today, basically saying, I don't want to rule otherwise just based on the letter of the law and I could rule otherwise, but I want this to be a fair hearing and case going forward, and for what's truly at stake here to be understood and heard by both parties and ruled on eventually.
He, you call it, he wants to be fair, and that's fine. I'll accept that. I'm going to call it, he doesn't want to be overruled on appeal. No trial court judge wants to be overruled on appeal. And any sort of, we'll call it a misstep, any sort of misstep by the judge is exact grounds for appeal. And he's not operating in a vacuum. He knows that Florida State lost its motion to dismiss in Mecklenburg County and is already appealing to the North Carolina State Supreme Court. And just the quick 30 seconds on that, because I know when we reported on that, I got hit up by a lot of social media attorneys who said, oh, you don't get to do that. There are all these steps in the appellate process. So let's cover that real quickly. No, actually, there are not. The North Carolina case is being heard in what's called the Complex Contract Court, which is for not your run-of-the-mill civil matters, but cases that have all of these complexities. And when it's heard in that court in the state of North Carolina, you actually do get to skip the rest of the appellate steps and go straight to the state Supreme Court, which is where Florida State is headed. We don't have a date for that hearing yet, but it will come probably in the next 2 to 3 months.
Okay, so next question.
Mm-hmm.
At the risk of not completely understanding the process, but for both Florida State and Clemson, with two battles being waged in separate states, of course, the home of the ACC and the home of the respective schools, they seem to be inverse arguments.
Yes.
Okay.
Yes.
What happens if, and maybe this is way ahead of things, but if Florida State, for example, wins at home and it's understood and it's approved that they should be able to wage this case in Florida federal court, but the North Carolina federal court determines that the case that they're working on should be heard in North Carolina federal court.
Right. It is, and you are correct. They are a mirror image of each other. The arguments are identical. The arguments that the ACC made in North Carolina to get out of, or to combat Florida State wanting to dismiss the case, are the inverse of what they're arguing here. There are some particulars with regards to North Carolina law versus Florida law, because these are still state circuit courts. But the arguments, you're right, Mark, are essentially the same. The fight is the same. Right now, it's a turf war. What happens in the case that of what you're talking about is at some point the cases would have to merge into an actual federal court. And whatever happens in Pickens County, South Carolina, we may as well throw the Clemson issue in there, for good measure. That is a possibility. To do that would put this probably about a year down the road, once you've exhausted all of these other steps. Look, one of the things that happened today with Judge Cooper in Leon County was his putting this motion off for a third hearing guarantees that, short of invalidating all of Florida State's contracts with the ACC in the next 3-4 months, there is no chance for Florida State to give it its departure notice by the August 15th deadline for next year. That's not going to happen. Not on this schedule, not in this time frame. So the only way for Florida State to get out properly is for a judge, any judge, to completely invalidate all of the contracts, the grant of rights, the membership agreement with the ACC. And Florida State, Counsel Rush started making some of these arguments today, and Judge Cooper stopped him and said, "You're arguing the trial matter, and as opposed to the motion, and that's why we're kind of getting this do-over." But when the two cases are running concurrent at the same pace, at the same pattern, yeah, you're eventually going to be looking at having to merge them into a federal court. One of the other things worth noting in this is there is what is called a stay of discovery. In other words, all of the discovery that Florida State has given to opposing counsel and that the ACC counsel has given to Florida State, there are no changes. There's everything is as is. And here's why that matters. Because the ACC has not turned over its entire contract with ESPN into discovery. Part of what the ACC and ESPN, let's note, this is very important, ESPN is co-litigants with the ACC against Florida State right now. And the reason for ESPN being involved is they're trying to protect their contract with the ACC. It is held in great secrecy. You know, we've heard before all of these things about the grant of rights is under lock and key at the ACC headquarters. It's not. We have a copy. We filed the Freedom of Information Act 2 years ago with a public university to make sure we could get it. It is the ESPN contract, though, that is heavily guarded in a secure room at the ACC headquarters in Charlotte. And ESPN wants to keep it that way. They're pleading with the judge both in Mecklenburg County and in Leon County, Florida, to keep that all private and secret. Their contention is if it gets out, then Fox will know how things were negotiated, and NBC and CBS. I think it's a bit naive. You and I both work in the media world, and we have for a long time. I'm pretty sure Fox knows how things go in these conference negotiations, as does NBC and CBS. And for all I know, the CW even knows it by now. But to that point, the ACC has submitted the ESPN contract into discovery and to the court with pages 1 through 160 being blank in order to protect intellectual property, I suppose. But it's to protect the trade secrets, as ESPN likes to call them. The judge allowed today that they can continue to keep the discovery that way. They don't have to submit anything else yet. But that, of course, is subject to further review should the trial go on and not be dismissed.
Tony Siracusa here from Last Word on College Football. We appreciate Tony stopping by to break down some of the more recent court happenings, and one that I was unaware of, which I should be aware of. We do a Florida State show every Wednesday, and they let me know, okay, this is coming up in 2 weeks and 3 weeks, and I should have put that on my calendar. But fortunately, Tony jumped on.
I actually have a whiteboard back here that is usually my schedule of games every week. Right now is all my court dates, you know, with Pickens County coming up next for Clemson.
You can have that whiteboard, Tony. It's all yours. I am not going that far. I will lean on you. So let me know if this bit of what I hope to be logic makes sense. Mm-hmm. The ACC's fighting on two fronts, and in a sense, fighting on four fronts at the same time.
Yep.
Therefore, I would think as much of this court findings, information, arguments become known, that Clemson can use what's going on and Florida State can take from and Clemson, or the ACC has to stay consistent, which becomes more and more difficult.
Yes.
It would be like me arguing a point against you and four others about the college football playoff. And if I thought my model was the best, you would all have opportunities to hit on weak points versus all the other models. And so it sounds as though, the ACC's task is twice as hard, truly, because of these arguments being very similar between Florida State and Clemson.
Yeah, they are similar. A lot of it has to do with when the grant of rights was signed and what is in there and what was excluded from there. Um, the As well as the revised ACC Constitution, which I know we talked about that last time I was on here. Waived our big copy, as we now have a copy of the ACC Constitution bylaws as well. And how it pertains in Florida law, North Carolina law, South Carolina law. Those are the particulars that the ACC has to kind of hone up on, for lack of a better word, right now. This is also why they are allowed to have lawyers from those states. Well, matter of fact, you have to have lawyers who are licensed in each of those states, who will be their experts in those particular matters. But the overarching argument, you're right, Mark, is the same. We want out. Here are the fees. One of the things that came up today was the amount of the fees, which are estimated to be 130 to 140 million dollars, and that's just to get out. That's not canceling the grant of rights, which is really the biggest issue, because leaving without your TV broadcast rights is of no value to any school. But that exit fee is actually a moving target, because what it says in the ACC bylaws is it is to be 3 times what the operating budget is of the conference at the time of the departure. Okay, well, that was signed 7 years ago. The operating budget of the ACC was a lot smaller then than it is now. Will likely grow next year. So Florida State's issue, Clemson's issue, the issue of other schools as they come up will be, you can't have a moving target like this. And we don't get a say as a member institution. We don't get a say in what your operating budget is. You just spend what it is, what you have in your coffers, based on your share of the TV revenue and other things. And we don't get a say in managing that, yet doing this drives up the cost to where it's now somewhere between 130 and 140 million dollars payable immediately just to leave.
And then, as you mentioned, there's a calculation of how valuable that TV property is, those home games going forward. Now, I don't know if that's going to be, there's a number of ways to calculate it. Simple math to say this is the ACC contract. We have 14 members. They play X number of home games, divided all evenly, or to say, which would be much more complex, to delve into the popularity of Clemson and Florida State,
Right.
which skews the numbers much higher. And then
Sure.
it's some kind of crazy formula to try to determine the future value of those games.
Yeah, look, that's a great point. And it was a challenging discussion to have today, because Judge Cooper, I'm going to say, he really doesn't know how the college sports landscape really works. It had to be reiterated at least 4 or 5 times that what we're talking about with the grant of rights are the home games, which, if you're talking about an ACC schedule, it's always ACC money because it's somebody's home game, right? And so it's on ESPN or the ESPN owned ACC network. So if it's Florida State versus Clemson, whoever is the home game, that's their broadcast game. But then Judge Cooper throws out, well, let's say it's Florida State against Alabama State. Not Alabama, mind you, Alabama State. And the attorney is sitting there going, well, I don't know if there's a TV contract for Alabama State if the game is there. I wouldn't even begin to know how we even quantify that. We kept having these theoretical questions from the judge, which really bear little to no relevance in the actual literal landscape of where we are with this contract. But to your point, there is no value to any school without its TV contract. You're not going to tell me the Big Ten wants Florida State, but can't have the rights to broadcast Florida State home games and own the revenue from that. There's no value in that whatsoever.
Tony Siracusa, last word on college football. Are you going to put this together as some kind of a summary that's going to be on Last Word?
It published about 15 minutes before you and I took to air.
There you go, folks. Tony, we are so appreciative of your time in the midst of putting that together for the written portion on Last Word on College Football. So just folks, consider that. Tony, very gracious of his time to give it to us while he's trying to process all of this, write an article, get it to Last Word on College Football. So Tony and everyone there, so kind to us.